Hello and welcome to the Kenneth for Camel Law Office Legal Podcast, the NJ Laws Tube, looking at recent cases decided by the New Jersey Supreme Court and appellate courts. And we're especially looking at cases that will be discussed at the seminar handling drug, DWI, and serious motor vehicle cases in the municipal court, sponsored by the New Jersey Institute for Continuing Legal Education, the New Jersey State Bar Municipal Court section, and the New Jersey State Bar Young Lawyers section. And in this edition, we look at searches by police, and in particular, can a commercial vehicle be searched for contraband during a routine safety inspection? And the Appellate Division held yes, a police officer who makes observations during a routine safety inspection of a commercial truck that he reasonably believes lead him to that it contains a hidden compartment containing contraband is not required to obtain a search warrant before undertaking to confirm the existence of the hidden compartment and determine its contents. That was State versus Hewitt, Cite 400 NJ Super 376, Appellate Division. Let's see him. Now, in DWI cases, the police are required to read what's called paragraph 36. It's a warning saying they have to take the test and they have no right to an attorney. And if they say no, then there's a second section to read. Well, what if the officer does not read the second portion of the warning? Should the refusal be tossed? Well, that's unclear. In State versus Spell, the Supreme Court of New Jersey held that they weren't going to throw out the refusal. They vacated the Appellate Divisions holding that requires police officers to read the final additional paragraph of the standard statement whenever the defendant refused to provide a breath sample, because he said the requirement of reading it would have to be by the Legislature and the Motor Vehicle Commission, which has authority to determine the standard refusal statement. And that was State versus Spell 142 NJ 514, decided by the New Jersey Supreme Court. There is a statute, unsafe driving, 39:4-97.2, and for your first offense, your second offense, there's no points. The statute says if more than 5 years go by, the next one would not be counted and you would not get points, because typically if you have a third offense within 5 years, you would get points. Let's say when is there points on this statute? Let's say well, the Appellate Division, although the statute says that if you go 5 years, you're supposed to get another one, the Appellate Division in Patel versus NBC said no. The Appellate Division held New Jersey's unsafe driving statute 39:4-97.2 requires that the Motor Vehicle Commission shall assess the driver points for a third or subsequent offense. The court also held the statute affords relief from the assessment of points when an offense is committed more than 5 years after the prior. In this appeal, the court construed the language to apply only to offenses that occur after a third. Now, certification was a grant in this case because many of us believe the Appellate Division was wrong in its dicta. Oral argument has been held and we're waiting for a decision. That's Patel versus NBC, and the Appellate Division site was 403 NJ Super 373, Appellate Division. In municipal court cases, the court rules bar a prosecutor from engaging in a plea bargain in DWI and certain drug offenses. Well, what about if the case is on appeal? Let's say if there was a conditional plea. Let's say, can you work out a better deal with the county prosecutor? Well, not in Mercer County. State versus Rastugi, no plea bargain of a DWI on appeal in Mercer. The Mercer court held the law division may not accept a plea bargain to resolve a de novo appeal on the record of a municipal court conviction for DWI. And that was State versus Rastugi, 403 NJ Super 581, Law Division, Mercer County. Let's see. School ground searches. Does the Fourth Amendment prohibit a school principal from searching a car on school grounds? Currently, no. The Appellate Division State versus Best said a school principal may search a car on school grounds if they reasonably suspect criminal activity. The Appellate Division held a school principal may search a student's car parked in school grounds whenever, under the totality of the circumstances, the principal reasonably suspects that evidence of criminal activity will be found in the vehicle. The court held, in light of the strong state interest in maintaining order, safety, and discipline in the school environment, neither probable cause nor warrant was required. Certification has been granted in this case and will be heard by the Supreme Court. The appellate site is State versus Best, 403 NJ Super 428. For additional information, contact the Law Office of Kenneth Buchanan, 732-572-0500. More information on the web at www.njlaws.com. That's njlaws.com, and benotguilty.com. That's benotguilty.com. And we're at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. In our next edition of NJ Laws 2, we'll talk about additional cases decided by the Supreme Court and appellate courts. Thank you and have a great day.